Hello, everyone, and welcome to Health Law Talk presented by Shahardy Sherman Williams. Before we get started, please be sure to subscribe to our podcast and follow us on Facebook, Twitter, LinkedIn, and YouTube, linked in the description below. We hope you enjoy this episode.
Good morning, everyone. So today you have Conrad, Meyer, and Rory Bellina, and we're going to be talking about a very interesting topic regarding advanced practice registered nurses, APRNs, or in some of the industry terms, mid-level providers. And specifically, a bill that was introduced in the Louisiana legislature in the 2021 session that was going to change how APRNs were going to be able to practice in the state of Louisiana. I mean, pretty interesting stuff. One of the critical issues with respect to APRNs is that they have to currently, as it stands right now in the law, the APRNs have to work with a physician under a collaborative practice agreement, which means this physician oversees them. So there's a new bill that was introduced to change that. Rory, what do you know about that?
Yeah, so as currently, like you mentioned, the collaborative practice agreement for APRNs has been around as far back as I know, and it's been put in place to kind of act as a protection and an oversight for APRNs, because a lot of APRNs tend to practice or have clinics in either rural areas or areas where there's not as much access to MD or DO physicians. And so the collaborative practice agreement has seemed to work well, but there's been some barriers for it, and there's barriers for APRNs, and there's barriers for the physicians that ultimately have to agree to be the collaborating physician with the APRN. So this bill was going to change things, and some people, most likely the APRNs, thought it was going to be for the better and it would allow them to practice more freely. And then some people thought that it wouldn't, that APRNs still need to be under the supervision of a physician. So it, like you said, it was brought up and it made it through the House. It made it through the Senate. It went to the Senate for a final vote, and they ran out of time. It never got called for a final vote, and it ended there, and the legislative session ended this week. So that's where things stand now. But I think we should talk a little bit about what is the collaborative practice agreement, why we think it's good, why we think it's bad, and let's talk about this bill, because we both don't think that this is going to go away, that it's going to get brought up if we have a special session or the next regular session.
Correct. I mean, I don't think it's going away. I mean, you and I might. I think, interestingly enough, you and I are on kind of opposite sides of the fence on this particular issue,
right?
And really, it goes back to a very interesting. What is it? Why was it necessary? So when the dawn, right, of the birth of APRNs, in addition to physician assistants, this sort of the mid-level providers, if you will, it was thought that, well, we're going to go ahead and introduce this. And in order to practice and give an expanded scope of practice, that those APRNs or physician assistants would have to work directly with a physician to be able to practice, medicine.
Right.
In terms of expanding their scope. So currently, as it stands right now, nurses, as they stand, usually have to follow the orders of a physician.
Correct.
I mean, facilities have policies with respect to things that nurses can and can't do, but normally the nurses do what the doctors tell them to do. And so the APRNs were sort of expanding that scope to address some of the shortfalls with primary care and access to care. And so that was the purpose.
Correct. And they had, I think, that right to do so, because APRNs are an advanced level of a nurse. They go to additional schooling, additional training, testing. It's a higher level of a nurse, and it's close. Their abilities are very close to that of a physician with some limitations. So, rightfully so. I think that the collaborative practice, it had good intent, but I think it restricted APRNs in some ways, and this was a push to kind of break the chains of those restrictions. And I think we should discuss, the pros and cons of a collaborative practice agreement, and, where we think this went wrong and how it can come back up.
All right, so, let's, in my view, let's talk about the pros. So
sure.
The pros, you have, in my mind, you have an individual, you have an advanced practice registered nurse, right, who is stepping out, right, on their own in a different world, doing more scope or increasing their scope of practice.
And likely in a rural area or an underserved area.
Well, I don't know if I would agree with that. I think you see APRNs in various settings. So I would agree that in a rural area or in a medically underserved area, MUSA, for example, I would expect to see that. But they're stepping out for the first time, and they don't have the same knowledge, training, and experience that a physician would have. For example,
I agree with that.
So for example, a physician's going to go to the 4 years of medical school and then another 4 to 6 years of additional residency and training before they're in their respective field. Whereas APRNs have to work a certain number of years in critical care, and then from there go to a school that I think obviously is a lot less time, and then suddenly they're thrust into practice, and you're dealing with patients on a whole new level.
Right.
It is you're the one making the decision. So no longer is the physician analyzing, doing the differential diagnosis, coming up with a treatment plan. That mid-level, that APRN, is now making those calls. Mm-hmm. So in my opinion, I think that the lack of that training, the lack of that knowledge, the lack of that experience could be a hindrance and possibly affect medical decision making for patients simply because they just don't know.
Right.
And so to have that physician oversight, in my mind, was critical to be able to, for me is a patient safety issue. I'm not look, I love APRNs. I'm not bagging on them.
Right, of course.
But I'm looking at it from a patient safety issue, and so that's why I thought they were important.
And I think it's important for our listeners for us to just briefly discuss what is the collaborative practice agreement and what typically is what's required in it and what is typically done. So, and the basics of it are that you have a physician, and the physicians are restricted to how many APRNs they can act as the collaborating physician for.
Right.
But essentially, they are the monitor, per se, of that APRN, and they're required to check in.
Well, I wouldn't just say a monitor. I think they're also someone as a sounding board, too, and oversight. I mean, to say monitor, it sounds like they're just watching the show, right? But do they have oversight?
They do.
They're involved in the decision making as well.
They do, and they are, like you said, from the monitoring standpoint, it's checking. They have to check a certain amount of patient records. Mm-hmm. They have to check in with the APRN, at certain thresholds, and to go to your point, it is a sounding board, because if a patient comes in and the APRN doesn't know how to handle that patient or just needs some advice, they have that collaborating physician to go to that can help them get that information. So I do agree with you. I think it's excellent for that. It's an excellent model, and I think depending on the setting, the physical setting of the APRN, you can make an argument on why this bill should have passed, and you could also make an argument on why the system's not broken right now. Let's keep it going as it is.
So to your counterpoint, why would you say, that's my pro? What's the con of having a collaborative agreement? Where do you see where the rubber meets the road? What's the problem?
I think the problem, from what I've heard from my APRN clients, is getting that collaborating physician and getting them to stay on. They're having to check in with the physician to say, did you check my notes? Did you check these records? We need to schedule our meeting. It becomes more of a administrative burden for them.
I can see that.
And sometimes an APRN wants to, they go through their training that you discussed, and they want to go back to their hometown or to a rural setting, and they really struggle to get a collaborating physician to sign up to do this, because I don't want to say it's a burden for the physician, but it's extra work for a physician to be a collaborating physician for the APRNs, and physicians are busier than anyone. So a lot of times it's more of an administrative issue, from what I've heard from my APRN clients, getting that collaborating physician and staying on top of him or her to get them to review the charts, to get them to review the records, and they're having to send in attestations that this was done to the various boards in the state. And if that doesn't happen, it's on the APRN. So that's the burden that I hear. Is it detrimental to their practice? No, but it makes it more difficult for them. Now, if they're not in a rural setting, if they're in a big city, or big parish, I don't think it's as big of a burden because they likely have a physician that will be that, and they're probably close in proximity. But otherwise, that's the position or the biggest con that I hear.
Right.
And I think why the APRNs were the big reason why I hear they were pushing to be free is that they went through additional training.
Free? What are we locking them up? I mean, I don't know if I would say free, to break the chains that bind them. I mean, the collaborative is not. I don't think it's just dead weight. I can see the administrative burden, what you're saying, but I don't know if it's as dead weight as that. I mean, I don't know. In other words, the physician has liability too. I mean, remember that. So,
they do.
So that collaborative physician, when they're not reviewing or they're taking their time to review charts, they could be running into some bylaw issues on chart timeliness. They could be running into some exposure, payer issues in terms of timely submission of claims, other liability issues. So they're on the hook too.
Correct.
So, but I can understand the doc who is sort of, I got to look at this again.
Right.
This, I can see that problem.
Right. And that's what I hear. So I think let's discuss, where this bill was and what it intended to do, and possibly why we think it maybe didn't make it out of a full Senate vote, and that it comes back up, and how it could be changed, or if they bring it up as is, do we think it'll make it?
So we're talking about House Bill 495, is that right?
Yes, House Bill 495 introduced in the 2021 regular session, and it was co-authored by numerous representatives out of the House.
Well, so let's, for the listeners, what is the normal, the process, right? It went to some committee first, is that right? And
Correct.
Then they go through committee and they do some revisions on the bill, right?
Correct.
And then after that, if it passes the committee, what happens next?
Then it goes, as you said, this one's authored by about 10 or 12 different House members. So it starts there. It typically gets sent to a committee. Committee reviews it, makes revisions. It leaves committee. It goes to the full House for a vote. Once it passes the full House, then it goes to the Senate. The Senate typically sends it to committee. The committees make revisions. Then it goes to the full Senate for a vote. This bill made it to the full Senate for a vote, but they never took a final vote on this. And that is common. That's not an uncommon thing. Why did they not take a vote on it? Was there something wrong with it? Typically, what we hear from people in Baton Rouge is that if a final vote is not made on a House bill or a Senate bill, it's typically because they know that it's not going to pass. And so, for lack of a better word, instead of them being embarrassed or, disappointing the people that they told it would pass or that were encouraging them to push it to get passed, they say, we're not even going to put this to a vote because we don't want that stigma of it failing and then us having to bring it up again. They would rather just let it silently go and bring it up again in the next session.
So to my point earlier about the knowledge, training, and experience, when you look at the bill and you look at the changes, it has some pretty stark changes to it in terms of the requirements now. So when you look at it and you kind of get into the weeds, now APRNs will have to have 6,000 hours of under their belt, right?
Right.
In a particular specialty. So, in other words, if they're going to go to, ortho, cardio, neuro, primary care, they're going to have 6,000 hours in their specialty to be able to get that APRN without the collaborative agreement. That was in the bill. And then, but prior to that, the as an RN, they needed to have 4,000 hours, clinical hours.
Right.
I mean, that is a tremendous amount of time.
It's a lot of work. And from what I hear from APRNs, they feel that the amount of time, work, energy that they've put in, that they should not have. Again, I'll bring up the administrative burdens that they have with these collaborative practice agreements, that they should be allowed to practice inside their scope. I don't think they're asking to do anything that they're not allowed to do by their license. I think it's more of a personal. I don't know if it's really an issue, but it's more of a personal struggle that APRNs have. That we got the hours, we went to the schooling, the training, the testing, we're licensed and certified, but then we still have to have someone who who isn't even an APRN, they're a physician. I mean, no, that's obviously a step above as far as training goes, but not even someone in our specialty kind of checking our work. And I think for them, it becomes that's more of a personal thing, because you don't see that in a lot of other non-healthcare related industries. And I think it's from the ones that I've spoken with, that's their struggle, is that in no other industry do you really see someone that's, not directly as you kind of checking your work and assisting.
I don't know if I agree with that. Let me flip the tables on you here for a second. What about paralegals and law? What if suddenly the Louisiana Paralegal Association said, well, we're going to give paralegals a license. They got to take 2,000 hours of training, and suddenly we're going to allow paralegals to go file pleadings. We're going to let them put their name and signatures on pleadings in court and allow them to do that. How would we respond? I mean, would we have the same arguments? Like, for example, the arguments I'm making, saying, well, hey, they really don't have the knowledge, training, and experience as a lawyer. They never went to 3 years of law school. They never did X, Y, and Z. So I don't know if I would buy that hook, line, and sinker. But because I can see that happening. I can see suddenly we're opening Pandora's box. Mm-hmm. But to your point, I don't know if I would agree back to the hours. Is 6,000 hours enough?
Right.
Is that enough? I mean, I don't know. I mean, if I'm a physician, for example, I've gone through 4 years of school. 2 of those 4 years, right, are on rotation. Then I'm getting matched into a residency program. That's only after I pass my boards. I have my 2-year boards, then I have my 4-year, and then now I'm in a residency program after I've matched, and I have another 4 to 6 years of additional training. Sometimes I go to a fellowship even after that. So does that 6,000 hours that was in the bill, right? Mm-hmm. Is that is that enough? Who's to say?
I don't think anyone knows. I think
that's the point.
That it could be an arbitrary number that we don't know. Is that enough?
We don't know. And the thing is will the patients care?
Correct.
And so that's a real point.
Right. So Conrad, is your kind of position on this that the system really isn't broken right now? Why change it?
No, I don't think that's I think that's a tough question, really, mm-hmm. honestly, because I do believe I understand the desire to break away from the contract, but maybe there's a way to meet in the middle. Okay. Maybe there's a way that you can allow APRNs to have the freedom and scope of practice, their desire, while giving patients greater access to care, but still having sort of that oversight of a physician, and I don't know the solution. I can't. I'm not a legislator, but I'm just thinking out loud here. Right. Maybe there's a way to thread the needle, right, to cover both ends,
and really find out what the position of the APRNs are. Is it that is there not enough?
Interestingly, I want to tell you this. Did you know that federally qualified healthcare centers, under the federal law, APRNs already don't need a collaborative agreement?
I did not know that.
They don't need it. So if you want to go work for an FQHC as a APRN, mm-hmm. you don't need it.
That's interesting.
And that's federal rules. So the feds already have taken the step, right? To cut the ties.
Right.
Now it's and this is a battle, and we all know this. It's a battle between the docs, right?
Exactly.
And the nursing board. So we're really watching the battle of the boards.
Correct.
Right? Because the bill also put together, you notice, interestingly, it advocated for this independent practice advisory panel with the Louisiana Department of Health.
I saw that.
And this was going to put together a 5 voting member panel.
Right.
And when you look at the panel makeup, now there is one physician from the State Medical Society, one from the Louisiana Medical Association, one from the American Academy, the Louisiana Academy of Family Physicians, 2 from the Louisiana Nurse Practitioners Association, one from the Louisiana Council on Administrative and Nursing Education, and one from the State Board of Nursing as a non-voting. But interesting, the one board member from the Board of Medical Examiners is a non-voting member.
Interesting.
So they wanted to pull that out, you see, because they don't want the board to I think to weigh in on this issue.
And I think it's up for it'd be a good conversation to find out where are the barriers. Is it that there's a restriction on the number of APRNs a physician can collaborate and oversee? Does that need to be expanded, or does there need to be more of an incentive for physicians to work with the APRNs? Do they need to come up with a mandatory program where every physician out of X amount of years of experience is required to be a collaborating physician for?
Then I think you're going to run real afoul from the physician side if you're mandating me to do that. I mean, I think that's a slippery slope.
I think the question or the struggle will be is, like you said, where can they meet in the middle? Find out what the real issues are and what the real barriers are, and how can this be worked out. So, I mean, the number one goal is patient care and patient safety, and no one.
I think also access to care too. Wouldn't you say? I mean,
yeah, absolutely.
So, patient safety, access to care, all the things you mentioned.
Absolutely, and by getting that, I think both boards need to continue working together to find out what is the best way to get that to everyone.
So let's just say this goes forward next year or the year after.
Sure.
Right? Let's just say another bill comes up, and this time it's going to get out of committee, it's going to get on the floor, it's going to get called. Mm-hmm. Okay, but here's the interesting thing, and I want to kind of leave you with this. What about physician assistants? If APRNs suddenly have the freedom to have no collaborative agreement, what do you think the PAs are going to say?
You think they're going to look at this and copy this bill and propose it for themselves?
I think they're going to give it a try, wouldn't you? I mean, if I'm a PA and I'm doing a similar scope of practice and suddenly my APRN next to me says, hey, I don't need an agreement anymore, see you, sayonara, right? Yeah, they're going to come back and say, I'm going to do it. We want to do it too.
And then are we opening it up? Are we opening it up to where we're going to have, like you said, the mid-levels just practicing
what
on
do you
their
think?
own?
You think it's going to? You think the Pandora's? If I'm a PA, and I see APRNs get special treatment because they put forth legislation, what do you think I'm going to do next year?
It could be. It could very well happen. The association could get together and say, we want this as well.
Correct.
And then we have that. Then we have possible other issues of trying to keep in access to health and patient care come up.
Well, not even in addition to the House bill. Remember too now the financial side of APRNs. Okay, on incident to billing, which we're not going to get into here. That's a whole different topic, right? But you have that 15%. Where they're reimbursed by Medicare at 85% on their own if they bill it on their own. But if they bill it with a physician, then they can bill it under the physician's NPI as an incident to if they meet requirements.
Correct.
But they get the 100% then.
Correct.
So there's a 15% gap. So I guess the question is that going to stay?
Right.
Or is Medicare going to say, hey, we're seeing the tsunami coming.
Right.
We're just going to go ahead and give them the 100% outright because we have, numerous states who are now letting APRNs practice on their own.
Correct. Yeah, and we don't know, and we need to see how this is happening in other states. With COVID and the expansion of telehealth and telemedicine, is it going to be more of a progressive approach where the goal is to get the most providers and the most access to patients, and finding ways to do that?
Well, I guess only time will tell. We'll see.
I think so.
We will see next year, the next legislative session, to see if somebody decides to put this forward. I think so. I think, you know what? I don't know. I think we've covered all of our rounds on the House Bill 495. I'm going to look forward. So. I'm going to keep. Who put this? Who was the legislator that drafted this? Was this?
It was Representatives Ivy, Carter, Cox, Green, James, a numerous amount of them. But it's something that we should definitely follow, and maybe we could reach out to them and find out where they think this bill didn't make it out of full Senate, and if they plan to bring it again in the next session.
I think that would be something great for a follow-up.
I think so, too.
Absolutely. Well, great. Well, that's great on this one.
Great topic.
Absolutely. We'll look forward to our next episode coming up soon, and I hope everybody continues to listen at the Health Law Talks at Shahardy Sherman-Williams.
Thank you. Thanks for listening to this episode of Health Law Talk presented by Shahardy Sherman-Williams. For more information or to contact us, please visit our website linked in the description below. Also, please be sure to subscribe to our podcast and follow us on Facebook, Twitter, LinkedIn, and YouTube.